Hi, it's Nate Charles, and welcome back to the Rule of Law Brief. After watching all the videos online of ICE ERO operations in Minneapolis, Minnesota, it occurs to me that you probably need a primer on what to do if you are encountered by ICE. So here we go. Now, just keep in mind, this video applies only to ICE enforcement and removal operations, ERO. Those are the people you're seeing in all the videos in Minneapolis right now. This video does not necessarily apply to HSI, Homeland Security Investigations, nor the FBI or any other criminal task force. HSI, Homeland Security Investigations, is technically part of ICE, but it is a criminal law enforcement agency with authorities similar to other federal law enforcement agencies like NCIS, FBI, you name it. ERO is different. ERO operates primarily under civil immigration law, and its powers are narrower than most people realize, especially when they're encountering ERO on the streets. If you remember nothing else from this video, remember the following. The most important question you can ask any ICE ERO officer is, am I free to leave? We say it again. Am I free to leave? That question determines everything that follows. So the first step in most encounters with ERO are as follows. Step one, ICE approaches you and starts talking to you on the street. Most encounters are going to start there. If an ICE ERO officer walks up to you and starts asking you questions, that is, at least initially, a consensual encounter. What are you going to ask? Am I free to leave? If he says yes, you have not been seized. Walk away. If they say no, you've just been detained. And we'll go on to the next step. The next step is an investigative stop. If the ICE ERO officer tells you you are not free to leave, it is an investigative stop. Now, an investigative stop requires the ICE ERO officer to have reasonable suspicion based on specific and articulable facts. Due to a recent and somewhat dismaying U.S. Supreme Court decision, race can be one of those factors, but it can't be the only factor. During an investigative stop, ICE ERO may briefly detain you, ask you limited questions regarding their suspicion, but they may not prolong the stop without developing probable cause, search your property without your consent or some exigent circumstance, which is an entire separate part of the law, or enter your private property. You may remain silent and you may refuse consent to the searches. If ICE cannot justify the stop, the detention is unlawful. The next step is a warrantless civil immigration arrest. This is the part that ICE very frequently gets wrong or hopes that you don't understand. ICE ERO does have the ability to make a warrantless civil immigration arrest, and that comes from 8 U.S.C. section 1357A2. Now, that statute requires that ICE ERO have two things, not one, both. One, ICE must have reason to believe that you are a removable person. That is, that you are a non-citizen in the United States and there is grounds to deport you. Probable cause of removability. Not suspicion, not a hunch, probable cause. Second, and this is even more critical, ICE must also have probable cause that you are likely to escape before a warrant can be obtained. ICE must have articulable facts showing that you are a flight risk. Those facts can include prior absconding, use of aliases, imminent departure, or other similar concrete indicators. If ICE lacks either probable cause of removability or probable cause of flight risk, a warrantless arrest under 1357 is unlawful. That standard is statutory. ICE does not get to waive it based on its own convenience. Now, level 4 is an administrative warrant. ICE ERO may rely on an administrative warrant, specifically a warrant written out on Form I-200 or I-205. Now, critically, these are not Fourth Amendment search warrants. These are not the kind of arrest warrants that you heard about when you were watching Law and Order. Administrative warrants are different from judicial warrants because they come from ICE officers, not judges. These are warrants that are created entirely within the executive branch of the U.S. government without getting a check from the judiciary. An ICE administrative warrant may authorize a civil arrest in a public place, but it does not authorize entry into your home, nor does it override the Fourth Amendment in any other fashion. If the door is closed and consent is denied, ICE must leave. Calling it a warrant really doesn't make it a warrant for constitutional purposes. That's kind of a misnomer. Now, the last step is an actual warrant, a search warrant or an arrest warrant. What we're talking about here is the kind of warrants that you heard about when you were watching Law and Order. These are judicial Fourth Amendment warrants. At the top of the ladder is a real warrant issued by a judge based on probable cause and limited in scope. With a judicial warrant, ICE may do what the warrant specifically authorizes, but nothing more. These are actually pretty rare in ERO operations. They are far more commonly executed by actual law enforcement agencies like HSI. In conclusion, ICE ERO's authority increases only as it goes up this ladder of actual legal authority. Most abuses happen at the lowest level, when agents rely on confusion and your compliance rather than lawful authority. And that's what the intimidation is all about. The fact that these guys are wearing military tactical gear and running around in camouflage has as much to do with confusing you as it does with any real threat that they are facing. It's about intimidating you into compliance so that they don't have to move up the ladder of legal authorities. And once again, if you remember nothing else from this video, the most important thing that you can say, and maybe the only thing that you should say if you encounter ICE is, am I free to leave? If yes, leave. If no, you have just entered a legally constrained detention, whether ICE wants to admit it or not. Stay safe.